behind in your court assessed fees. Is that true or not true?
Yes, ma'am, it's true.
Did you enter your pleas of true to counts 3 through 9 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes.
Now, I don't want to get into, I'm not asking any questions, but with regard to counts 1 and 2, I do want to make everyone aware that if we come here and there's a hearing and you act, I don't want us to have to come and have a hearing, have officers come, if in fact there's something that is blatantly true. It's not going to help you if you're not taking responsibility.
Yes.
If you actually didn't do it, that's fine. That's what the hearing's for. But just to not take responsibility doesn't sit well. Does that make sense?
Yes, ma'am.
All right. So are we good with what we pled on then?
Yes, ma'am.
Okay. Then I'm going to find that you entered your pleas of true to counts 3 through 9 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I am going to reset your case for a hearing so that the state can bring witnesses with regard to counts 1 and 2. We'll get an updated pre-sentence report done. And I'm guessing
Not long, Judge.
not long, so maybe even on 11 o'clock.
Yes, ma'am.
Okay, so we'll set it on a regular docket date, but at 11, so we can have any witnesses. Anything that you think is important for me to know, get that information to Mr. Wilkerson. He'll present it to me on your behalf when we come back.
And just for the court's information, Judge, once we have those underlying issues dealt with down the hall, then those pleas will change. So it's I'm just giving you a heads up, because if we set it for a hearing right now today and we're able to get those dealt with beforehand, then we're subpoenaing witnesses when a hearing wouldn't be.
Well, that's what I'm saying. I don't want to do that. So if they're true, they're true. I don't want to, I mean, if you need time to take care of something, that's one thing, but to stand and swear under oath that something's true or not true is putting Mr. Josie in a position of, I don't know what you mean by taking care of them, but if he's going to go plea on some cases down the hall and he just said under oath that it's not true, then we have an issue.
I would like to establish on my square morale.
Hold on. I want you to talk to Mr. Wilkerson. Let's figure out the timing of all this, because I don't want to do it this way, if that makes sense. So I don't want him to have to subpoena witnesses. I don't want to get close and then we keep doing this and we show up and then there's some deal that's made and we've got officers who either just got off a night or whatever that had no reason to have to be here. So I've taken the pleas. I'm going to reset it at this point for a sentencing hearing. However, I want to know within at least a week before that hearing, if I want Mr. Coleman to know if he has to get those witnesses here.
Yeah.
At least 7 days. Okay. All right. You can go back with the bailiff.
Thank you.
Thanks, Judge.
Thank you, Your Honor.
Yes, sir. Good morning. Are you Eric Hebert?
Yes, ma'am.
And this, we've got two cases, 21-37340 and 21-37341. Both of those cases, Mr. Hebert is on probation and motions to revoke those probations have been filed. And what is the announcement?
Judge, if I may, he has a new DWI third. I've spoken with this officer, Ms. Kane, about that. I checked last week. It had not been received. Mr. Nichols was kind enough to check again this morning. The blood test results are in progress, or whatever that means. So I would ask the court if we could either go through the motion, see what pleas he will enter or hold for maybe 30 days just to allow that new case to come in. We had discussed safety as a possible resolution to pose to the court. Obviously, you can go with the new case outstanding. Obviously, the new case I will not dismiss. And obviously, the court would want to see the new offense before you would determine if safety would even be an equitable option. So that's kind of where we are. Whatever you want to do, either go through it or reset it, and we'll stay on top of that new offense for March.
Oh, that's the agreement with the defense. Yeah.
This is a critical moment in the hearing. The judge is already signaling concern about a new DWI allegation while the defendant remains on probation. That's the kind of development that can dramatically change the court's outlook.
I mean, I don't guess it mattered. At some point, he'll have to enter pleas of true or not true. If y'all want to go ahead and do that, and then we can reset it.
I mean, that would help me expedite that case, but I don't want to put him in a position where he pleads true to it and doesn't get safety and thinks I've.
Well, that's going to be, and I mean, if you're on probation for driving while intoxicated, third, and there's another one, I don't want there to be any thought that I will for sure go along with something like that. It's going to take me looking at, I have no idea right now, but that just off the top of my head sounds like a big no, but I'll, obviously see the new case and look at what's been going on in this probation. I just, I don't want there, I don't think an agreement right now to that.
Your Honor, I understand that. I've spoken with the prosecutor. I've explained to Mr. Hebert the position that we're in, and that's not a part of the understanding that there's any
Right.
Agreement.
agreement.
No agreement. So it's just what you guys obviously
it was
would
just
recommend. Sure. So do we want to go through the motion today then?
We can,
Or,
I'd rather have which one would expedite the,
A plea would, because I could push it through without the lab, but if in all candor, if everybody wants all the information, just let me make a call and ask them to move it along.
all right, we'll just
Let's do
reset. I'll
that.
just do a normal reset.
Thank you, Your
See
Honor.
if y'all can get that taken care of.
yes,
All
ma'am.
right, and go back with the bailiff. Good morning. Are you Isis Martin?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Your Honor.
Ms. Martin, in clause number 25, DCCR 1827, you're charged with the second-degree felony offense of robbery, and that's from October 14th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you?
Yes, ma'am.
You have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation?
This exchange reveals exactly why probation cases can become so complicated. The court isn't just looking at the original offense. Anymore, it's evaluating what happened while the defendant was already being given a second chance. A new DWI allegation hanging over the case creates major uncertainty, and Judge West is making it crystal clear that no outcome is guaranteed. When a judge openly says something sounds like a big no, that's a strong signal that the defendant has an uphill battle ahead. What do you think's hold? Someone facing a new DWI while on probation be given another opportunity? Or is this where the court needs to draw the line?
Exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Ms. Martin's not competent?
No, Your Honor.
Right, ma'am. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back later for sentencing. Mr. Smith, what is the state's position with regard to a bond reduction based on the nature of the plea?
Yes, history, guilt.
I'm sorry.
Yes, no criminal history. This is wrongly arrest.
All right, so you don't have any objection to it? So, Ms. Martin, what I'm going to do between now and sentencing is reduce your bond to $1,000, and I'm going to make that a personal bond. So that means you don't have to pay any money. You're just going to get out of jail. But there's some very important things about that, okay? The first is that if you don't show up for court, then they can come after you for that $1,000. But that's probably going to be the least of your worries if you don't show up for court. If you don't show up for court, you run the risk of me not accepting the plea agreement, and things could obviously be much worse. The first thing you do when you're released from custody is go to the probation department. You're going to get some paperwork today from probation. It tells you where to go so that they can start that process to get that pre-sentence report done. If you don't go straight there, you also run the risk of me not accepting the plea agreement. Do you understand that?